Okay, now I'm live. Okay. This is this case somebody was telling me about. I want to get some other people to look at it with me, you know? Whenever they come. Whenever they get here. It usually takes about 30 seconds to get somebody in there. Okay, somebody on TikTok told me that the federal constitution doesn't apply, that only state constitutions does. And I asked him what he meant. This is what he referred me to. So I've glanced over this, but I'm going to put the link in the description because I like for you guys to look at it and see what you think about it. It's called Barron versus Baltimore, 1833. Okay, so what they're saying is, hey Patrick, hey Bloodline, they're saying is it's a landmark decision that influenced U.S. constitutional law for almost a century, limited the reach of the Bill of Rights to the national government. The Supreme Court reasoned that framers of the Constitution did not intend the bill to extend to state actions. Hey John. Barron sued Baltimore for taking his property without compensation. I can't say that word right now. Compensation. The case arose from a series of street improvements made by the city of Baltimore that required diverting several small streams. As a result, large quantities of dirt and sand were swept downstream into the harbor, causing problems for wharf owners, including John Barron, who depended on deep water to accommodate vessels. Good morning, everybody. It's good to see you guys. I can't see them. I'm going to move it over so I can see. His business damage, he sued the city of Baltimore to compensate for his financial losses. He claimed that the city's activities violated the Fifth Amendment takings clause. That is, the city's development efforts effectively allowed it to take its property without compensation. Barron sued for $20,000, but the county court awarded only $4,500. Supreme Court said Bill of Rights did not apply to state and local governments. When the Maryland Court of Appeals reversed that decision, Barron took his case to the U.S. Supreme Court. There, the court raised the constitutional question of whether the protections of the Fifth Amendment and more generally the Bill of Rights apply to states and local governments. In a unanimous decision authored by Chief Justice John Marshall, the court ruled the Fifth Amendment did not apply to the states. The decision stood in contrast with many, hey slow burner, major landmark decisions of the Marshall Court that expanded national power. This shift was a function of changes in the composition of the court, and probably a natural retreat from the strong nationalist tendencies of the Marshall Court. In his opinion, Marshall wrote that the question raised by the case was of great importance, but not of much difficulty. Indeed, the court had not even required Maryland's General Attorney Roger B. Tanley, Marshall's eventual successor, to appear for the state. Marshall argued that the drafters of the Bill of Rights were specifically trying to halt potential abuses by the central government. He wrote, the provision in the Fifth Amendment to the Constitution declaring that private property shall not be taken for public use without just compensation is intended solely as a limitation of the exercise of power by the government, is not applicable to the legislation of the states. And then it says the decision was a motivating factor in creating the 14th Amendment. And it permitted many states from making their way to federal courts, many state cases. It also left states free to disregard the Bill of Rights and their relationships with their citizens, who were left to rely instead on state laws and constitution for the protection of their rights. Eventually, the decision was a motivating factor in the construction of the 14th Amendment by post-Civil War Congress. Some sponsors were intent on ensuring that this amendment applied some or all the provisions of the Bill of Rights to states. Although the Supreme Court has never expressly overturned Barron, the selective incorporation of the Bill of Rights to the states, beginning with an incorporation of taken clause in Chicago, Burlington, and Quincy Railroad Company versus Chicago, 1897, and spreading it to provisions with Gitlow versus New York, 1925, has made the case more of a historical landmark than a limitation on the current reach of provision of the Bill of Rights. The court has now applied all provisions of the First Amendment to the states. Now, I don't know exactly what this means. I mean, I'm just reading it, and I'm going to share the link, but somebody on TikTok, he said that, which I've already known. Amanda already told me that we need to get more into our state constitutions. But, I don't know. Hey, Snarkus ass. Hey, Nude. Hey, Randy. Hey, Karen. Good to see you guys. Lady Justice. I've been trying to call you. I can't get through. Slow Burner. Who else did we miss? We missed somebody. Christy. Is that how you say it? Christo. I'm sorry. Christo. I'm sorry. And I think we got everybody. Yeah. Anyway, guys, so I'm going to leave a link to this. This guy was telling me, he wasn't trying to be rude or nothing. He was just telling me that when Soliaker was speaking at the city council meeting, he was quoting the Constitution that it doesn't apply. And I said, doesn't apply to who? And he did a little, what do you call it? It's like on Clapper, they call them clapbacks. But on TikTok, it's something like that. He did like a little clapback. So I don't know. Oh, you're at Geo's? No wonder you ain't got a connection. So I don't know, guys. I mean, what do y'all? I don't know. It's hard to ask for your opinion on this when you haven't read it, and I would like for you guys to read it. I don't know. It seems to me like this happened so long ago, and then it was like, and then they mentioned cases that come after that. But I don't know. So we need to know more about this. It is interesting. So I'm going to share the link with you guys. And if y'all have time, try to look over it. Because, the more people we can get to look at these things and try to understand them, the better. I'm not a lawyer. I don't know anybody here that is. But I do believe a lot of us do know more about law than the police do, at least. And most government. So I do ask you guys to look at this. So when you get a chance, look at it, and hopefully we can get together again and discuss it. Maybe we'll do a panel. Share it with some other people. Let's get some of our smartest, most law-thinking people, to look over this, okay? All right, well, I'm going to let you guys go. I appreciate y'all joining me real quick. It's definitely something that needs to be looked at, because when we're going out to fight these things, we need to make sure we're quoting the right things and definitely. So look into this, and I will catch you guys later. Make sure you leave a like, and we'll talk soon, okay? Lady Justice, if you can call me, please do. Use Geo's phone. All right, I'll catch you guys later. My name is American Amy, and I'm signing out. Bye-bye.